administration is offering a new chapter in immigration enforcement, this time targeting people who've already become U.S. citizens. The Justice Department is now looking at revoking citizenship from naturalized Americans with criminal convictions. To break down what this shift means and who could be most at risk, we're joined now by immigration attorney Mariam Masumi Daud. Thank you so much, Ms. Daud, for joining us. I want to talk a little bit about this mandate that is coming from a letter that was written by Assistant Attorney General Brett Shumate. It lists a number of kind of priorities that they want agents and the federal government to sort through. Can you kind of name what some of these priorities look like?
Yes, the Department of Justice received a memo from the administration delineating 10 different priorities of individuals who could be reviewed for purposes of naturalization. This could be individuals who fail to disclose certain information on their applications for naturalization when they were going through the process, such as prior criminal arrests or convictions, as well as individuals who may have been engaged in national security issues or have been involved in terrorist organizations or funding terrorist organizations. So it's a really long list, but what's most concerning is at the bottom of that memo, it does say that these priorities are not in any particular order, meaning that somebody who's kind of listed at the top as a national security risk versus somebody who's listed at the bottom who may have made an omission on purpose or not on purpose, they're treated the same. And in addition, it does give prosecutors broader authority to prosecute or bring forward naturalization claims by any case permitted by law. So that language is very broad, it's very vague, and it really opens up the door to seeking denaturalization of millions of Americans.
I'm glad you mentioned that because that number 10 out of 10 really stuck out to me, and I'll read it with you. Any other cases referred to the civil division that the division determines to be sufficiently important to pursue, basically saying if it's not covered in this other list, any other reason to try to pursue denaturalizing a citizen can be pursued. Can you talk about what that could look like in court? Can that legitimately hold up?
It certainly could. For example, if somebody were filing for a green card to come to the United States and their parent was bringing them over here, that process can take a very long time. It can take years. And if during the wait time for that person to come here on a green card, let's say they get married, and initially when they filed the case, they may have been single. If they fail to advise the embassy when they're seeking their green card that they were married, maybe they forgot about it, maybe that just so much time had passed, they didn't update that information, and then they come to the United States on that green card, ultimately become a U.S. citizen, that failure to disclose that marriage actually is grounds for denaturalization, so that the government go back and review that file. So people who make erroneous misrepresentations, again, whether willful or not willful, are vulnerable to potential denaturalization should the government go back and revisit their entire history.
I mean, that's just one example, and the naturalization process is one that is extremely complicated, not to mention most of it is entirely in English, and we were talking about these people who are looking to become naturalized citizens. There are some moments where a language barrier can become a legitimate barrier. So can you talk about how easy it is to make some of these mistakes because of how hard it is to understand this process?
Absolutely. Immigration forms in general are very complex. There are a lot of questions on the applications, and a lot of the time people have a hard time understanding what's truly being asked of them. And in my years as an attorney, I've seen that firsthand, where individuals make mistakes because they didn't realize that they needed to disclose certain information, or they didn't understand that they needed to inform the government about certain areas of their life because there was just misunderstanding or they weren't clear on the process. So language can certainly be a factor, education can be a factor, and just a lack of familiarity with the process in general.
Ms. Daud, I'm going to ask you real quickly, real briefly, to just summarize what populations you think are most at risk.
Well, at this point, we have 25 million Americans in the U.S. who are naturalized, and certainly with the language of this memo, it makes pretty much anybody vulnerable who may have had issues in the past that weren't disclosed. But this tool has been used to target certain populations, certain demographics, people from certain countries. We've seen that historically, and it could be something that the government could use as a weapon to target certain racial groups as well.
And again, real briefly, has this tool been used legitimately in the past to actually remove people who have cheated the system, people who have committed crimes to gain immigration status, or rather legal citizenship status?
It certainly has. I mean, denaturalization is something that has resulted in the removal of people who've been convicted of very serious and dangerous crimes, as well as former members of the Nazis or Communist Party. But this is something that is used very rarely. It is not something that is common. During the Obama administration, there were roughly 300 denaturalization cases. But when we had the Trump administration the first time around, they were reviewing about 2,600 cases. So that just shows you just the increase over time in which this process is being used, and there's a major concern as to abuse of the process.
Okay, we'll leave the conversation there. Mariam Masumi Daud, an immigration attorney, thank you so much for your insight and your expertise.
Thank you for having me.